adjourned on the case of H&D Hobby versus Mr. Svatos. While we're waiting, let me fill you in on the case. H&D Hobby, represented by the president, Mr. Madsen, sued Mr. Svatos for the debts of unpaid inventory supplied by H&D Hobby. I'm hoping to catch a word with the lawyers before they leave. Oh! Here comes Svatos! Svatos!
No comment, no comment!
Well, that didn't go over so well, but let's go inside and see what we can see. Oh, look, here are Madsen and Svatos' lawyers. Follow me.
This is ridiculous.
Hey, aren't you Madsen's lawyer? Tell me about the case.
Well, first, my client agreed to supply products to Svatos' store, H&D Hobby, and extend his credit. Svatos never said anything to my client about operating as a corporation.
Weren't all payments from Svatos' store made by check with a heading that included the name of the corporation? Therefore, shouldn't your client have known or at least inquired about Svatos operating under a corporation?
Well, my client never even saw the checks because he's not in charge of accounts receivable. Most importantly, though, Svatos sent my client a letter reaffirming his personal obligation to pay his outstanding invoices. Svatos signed it personally without any mention of a corporation. This is an obvious violation of the Business Corporations Act. This letter was the reason my client Madsen quadrupled the amount of business he's going to do with Svatos.
In regards to the Business Corporation Act, he must put the name of the corporation on all documents, correct?
Correct.
So Madsen accepted the letter as a personal promise?
Of course, and my client was generous enough to be lenient in the due date and also advance the shipment of goods. Apparently, Svatos even had a letterhead with the corporation's name set up on his computer, but didn't even use it.
No way.
Also, no reference to the corporation was made on any signs or business cards. And the icing on the cake is that Svatos' business was failing, and he gave preference to one creditor over another by liquidating the unpaid goods supplied by my client. He did this completely for his own benefit. This is not an example of acting as a separate legal entity from the corporation.
Shut up. That is basic principle of company law. How dishonest.
This is ridiculous. This is ridiculous. I want my part of the story told.
No comment, Svatos, no comment.
So, is it true that your client never let Madsen know he was dealing with a corporation?
No, my client did tell Madsen that he was dealing with a corporation, 327401 Alberta Limited. It's not that hard to remember.
34271 Saskatchewan?
No, 327401 Alberta Limited, but the company operates as H&D Hobby, so they were the same thing. Both names are clearly stated on two places on the check, in the heading and in the place above the signature. These checks were sent to Madsen all the time.
So why didn't your client include the name of the corporation in the letter that he sent to Madsen?
No comment.
Well, there you have it. Now, is Svatos personally liable to Madsen for the debts due? Did Madsen really know, or should he have known, that he was dealing with a corporation? Did Svatos commit fraudulent or dishonest acts to the detriment of Madsen? Well, don't change the channel. I'm Christiane for BSN News. Now back to the newsroom with Charlotte and Jeff.